The Kohler, how do you pronounce the name? Kohler? I'm still
I don't know,
having
you'll have to ask the witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those three, whatever order you want, but I'm not moving past those three to jump to others.
I didn't say anything about moving past the three.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find the
I understand,
paperwork.
but that's paperwork's on you, not anybody else.
So what am I supposed to ask him?
I can't answer that, sir. You know that.
That's a rush to judgment. You can't rush me to judgment when I'm notifying the court that I cannot find the record. You took these oaths of offices. You did, Your Honor, 3 of them.
I understand my oath,
which is
sir,
very
well.
commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths.
All right, I'm going to have to excuse the jury since Mr. Brooks is not calling his witness. We'll hopefully bring you back out shortly.
You have to honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant. I just feel like it's smart for them to be tested, so it doesn't come up again in the future, or potentially come up again in the future, because then we'll all be looking back and saying, well, we could have prevented something like this from happening if we had just nipped it in the bud from the get-go. It's just smart to, like you say, err on the side of caution.
I appreciate that. I'm going to continue. I understand what you're saying, but given the responses of the jurors today, I'm going to continue. I'm going to base this off of their desire to continue, at least what I would interpret as their desire to continue with their service on this case. All right, then I want to talk briefly about any position on that, Mr. Brooks?
Yeah, I don't see the relevancy of the map.
It's directly related to her testimony, sir. It's relevant. Your objection is noted.
So
it's overruled. Exhibit 7B is received.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I am squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the rule for your closing argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling.
I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
If it's criminal or civil, so I can hit you with you.
I need to clear the courtroom because I do need to
I'm gonna give you what you know is coming.
I need him to go to the
If
other
it's civil,
courtroom because I do need to put some things on the
civil,
record. The record to
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no,
to the
it
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's system.
But the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
I don't remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Mr. Brooks, there's a proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
I
So
respectfully
you are
object to
once
that, Your
again reminded of that.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you
of
may
the
not,
court?
sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I'm
had
under
a
duress
dozen
by
or more
having
interruptions.
shock. I
You'll
have
be
shock-
off the record while
shocks
we
on
do
my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. Or I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to.
If there's anything he needs to make a record of at this point on the topics that have been raised. So, anything you wish to address before we break for the day?
Yeah, I can. I wasn't really hearing everything that was just said. Good.
The reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant.
I'm supposed to be in this admiralty court because you haven't if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even
And
need to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this
I
morning.
just wanted it stated for the record that
Mr.
I'm not
Brooks,
identified by the
it
name
wasn't
that
the
you called me
proper
by.
time
That's
to
all.
do that. That's now the third interruption.